Hello, I am delighted to be with Roger Stritmatter today. He is a professor of humanities at Coppin State University. He is the author of many books and articles, scholarly articles on Oxford and the Shakespeare authorship question. For those of you who are members of the Shakespeare Oxford Fellowship, he is the author of this absolutely important book. How to get it right here? Here we are. On the date, sources, and design of Shakespeare's The Tempest. And if you're going to Ashland, you may be going to see that. So brushing up on it ahead of time might be a good idea. The co-author wrote this book with Lynn Kositsky. So today we are going to talk about his new publication, Shakespeare and the Law: How the Bard's Legal Knowledge Affects the Authorship Question. So Roger, thank you for joining us. Give me a sense as to when you decided to research and edit this book.
Well, that's a really interesting question, because since I first met Tom Renier in, I believe, 2004, I wanted to edit a book with him on the subject of Shakespeare and the law. And sadly, that book had to be done after he had passed away from COVID. But it was one of the things that was very meaningful to me about doing it, was that it was dedicated to Tom, and contains 3 essays by him. And I just wanted in the book to carry the discussion of Shakespeare's legal consciousness. I'm going to use that term, even though it's, some people might object to it, but his legal consciousness in the plays. And what does that have to do with the authorship question? And it turns out that the two things have a great deal in common, and they're sort of like a pair of gloves almost, in a way.
Mm-hmm. Tom passed away 3 years ago, I think, almost right at the beginning of the COVID epidemic.
Right.
And it was a great loss to scholarly research in the Oxfordian field, and obviously, especially to you, but to all of us as well. Many of these articles that you have in your book were written decades ago. And I think the earliest one was Underhill's article, was what,
1916, yeah.
Yeah. So the question of Shakespeare and the law goes back now more than a century.
Oh, yes. It goes back at least another half a century before Underhill, and I think really actually more like probably a century. Yeah, it's a long discussion and a long debate. So
in terms of going back in time with those earliest articles, they talk about Shakespeare as the author, because certainly Oxford was not identified as the author of the plays until 1920. Underhill's article is 1916.
Right.
But at what point, if any, does Oxford really become identified as Shakespeare, and so his legal knowledge gets assumed within the plays?
Well, I would love to answer that question, but I'd like to start by answering a slightly different but related question.
No problem.
Say something about Underhill, because Underhill's essay proves that it was before Loney that traditional Shakespeareans were already scared of the subject of Shakespeare's legal knowledge. And I say that because Underhill's essay has a remarkable character to it. The first sentence essentially denies that Shakespeare has any sophisticated legal knowledge at all. But rather than following through on that claim in the rest of the essay, Underhill takes us on what is really a very useful and entertaining and educational survey of the different institutions of law in 16th century England, including each of the Inns of Court, and really gives a lot of insight into how the legal profession operated at that point in history. So the article, I included that article to illustrate both things, that for some reason he felt, in writing for a book on Shakespeare's England produced by Shakespeare experts, that it was required of him to deny that there's any intellectual sophistication in Shakespeare's knowledge of the law, but he by no means demonstrates that conclusion. In fact, he doesn't even really consider it, having put it out. So that's already happening before Loney, who of course Shakespeare identified, comes out in 1920 in both English and America. And it doesn't take very long for that book to begin to have a real impact on people like Sigmund Freud and John Galsworthy and any number of really prominent British intellectuals and creative people. Notice it very early, and it's influencing their thought, earlier than you might think. One of the interesting examples is Virginia Woolf, and her Orlando, her novel Orlando, is definitely bound up in this question about Shakespeare's identity.
Really?
Yes. I mean, Orlando is the protagonist, right, of As You Like It. Also, there's a whole tradition of Orlando that goes back before Shakespeare, but that's the Shakespearean aspect of it. And so by the 1920s, Loney's book is having this really significant impact. It's not the only theory about who wrote the plays that's around at that time, but it's rapidly becoming the most influential.
I hadn't known about the Wolf book. I knew it existed. I hadn't known about the connection to Oxford. So that's next on my list.
I don't know if there's an explicit connection to Oxford. Okay.
Okay.
There is a exploration in fiction of concepts that are, I believe, inspired in part by the existence of the mystery and the problem of Shakespeare.
The question of where the author went to study law, if not law school, is mentioned in an interesting way here in the article. Well, it's still in Underhill's article. He talks about the 4 Inns of Court: the Middle Temple, the Inner Temple, Lincoln's Inn, Gray's Inn.
Right.
And he says if you'd banded them together, you would have had a law university. I believe we think that Oxford went to Gray's Inn.
He did go to Gray's Inn, which was the most aristocratic of those institutions. And that was sort of the one he would quite naturally go to. And it also appears to have been the most literary of them, or certainly had a reputation for literary events like putting on masks and things like that.
Putting on a mask in a law school, that would seem to be some inadvertent or indirect training for a dramatist. Is that how they studied the law?
It's also training for forensic pleading, right?
Yes.
Lawyers need to be good at making forensic plea. I mean, I can't imagine a better handbook for making forensic pleas than Shakespeare. And they're all over in the plays. Characters beg for forgiveness. They prosecute other characters. All kinds of forensic rhetoric takes place in the plays. And so, yes, he went to Gray's Inn. And he also, and this is something I did not even focus on. I may have read it, I think, but the significance of it did not occur to me until I got some help, in this case from Dorna Bewley, on the writing the introduction and the conclusion to the book, and realized that from about, when is it? About, I think 1572 approximately, to the end of his life, Oxford was on an international tribunal, which was the trier of petitions from Gascony. And that meant that not only was he a judge as part of this tribunal, but he was a judge. He was one of several judges who were overseeing disputes involving British and French competing claims in Gascony, an area that had been, I believe, under Edward III, if I'm, don't quote me on that, but it had been a major territory of England for a while. It's a place that England and France fought over for a very long period of time. And so obviously this is an extremely sensitive sort of diplomatic, legal position. It's a position of great influence. And he remained on the court until his death. He, in 1604, when he died, he was a senior member, having served on it for over 30 years.
How would presentations to courts like that work? Would an individual go before the bench and make an argument? Would there be disputants from two sides?
Well, you're testing my knowledge of the specific operations of this specific court. I mean, part of what I liked about Underhill's article, and why when I realized it was out of copyright, and that, you know, it really would add a fascinating additional dimension to this, because the other readings all pretty much take the other side and say, no, there is something significant here in this person's knowledge of the law. And a lot of the criticism of that has come from people that have refused to acknowledge that, you know, Shakespeare is writing drama. And so you sometimes can't try to apply literally whatever legal concept is being mentioned. It's coming out of the mouth of a particular character in a drama, and therefore it's as much about the character of that character, the ethos of that character, as it is about some sort of abstract, rational knowledge of the law. But everybody else in the book pretty much argues that, you know, he's a Supreme Court judge level of knowledge of the law, not a lawyer, but actually a judge.
A judge. One of the things that I found so interesting in reading these articles was you can see how it really does matter who wrote the plays. It's not just happenstance. It's just some guy decides to write some fancy words and let's call it law. But
No.
he knew what he was talking about.
He knew what he was talking about, and the plays always have, I believe, a topical dimension to them. He is responding not just to, you know, using his sources to entertain people, but he is responding to the big events of his day and, you know, writing plays that are relevant as well as grounded in their historical sources and, you know, full-bodied in their dramatic potential. He cares about what's going on, and he's usually not commenting on it in a direct way, but indirectly he is. And when you realize that that's happening, you can understand the plays in a much more fine-grained and deeper way. You know, one good example would be that people are familiar with, you know, when Hamlet slays Polonius, he says, "Dead for a ducat, thou findest to be too busy as some danger." And the historical inspiration for the character Polonius was Edward de Vere's father-in-law, William Cecil, who was the Lord High Treasurer of England. So suddenly that thing, dead for a ducat, you know, and thou findest to be too busy some danger. Cecil really was the most powerful man in all of England because he was involved in so many things, spycraft and the treasury and the key advisor to Elizabeth, and all those things were kind of in his hands. So you can see that, and these two have a very complicated relationship, because Shakespeare also, honors Polonius for his wise sayings. Who can argue with never a borrower nor a lender be, and etc.
Right.
So the plays always have that dimension to them, and it's really the Oxfordians, I think, who, for the most part, understand that better than Stratfordians do. Although there are certainly plenty of traditional scholarship by traditional Shakespearean scholars that supports the idea that Polonius is based on Burleigh. But some people object to that because they see the implications of that for the authorship question.
Of course they object.
Therefore, they don't want to go there.
Right. In another article that I found really interesting, Burton's article, which was published, I think, about 2000, J. Anthony Burton.
Yes. I think there are two articles in here by him, actually.
Oh, okay. Well, this is...
I think he actually has written 3.
This is page 171 in your book.
Oh, you know what? This was originally published as 2 articles. That's why I'm a little confused.
Right.
But
oh, yeah, it says that.
Yeah, it was a 2-part article.
So what I just wanted to look at was the idea that on page 172, he writes, in 1990, J.H. Baker published a catalog of English legal manuscripts in the United States, including unpublished notebooks by James Dyer, the chief judge sitting on the Hales case. This is Hales v. Pettit, which sits in the middle of Hamlet. Dyer's surviving notebooks are, quote, the earliest known continuous circuit court notes kept by a judge and were eventually published in 1994. Among them were Dyer's own record of the hearing and an anonymous second report. It seems to me that until 1990, we didn't have that full an explanation of Hales v. Pettit. Is that accurate?
As far as I'm aware, that is accurate.
That's amazing.
I would say that there's a lot of things that are issues, elements of fact pattern that are important in the authorship question that are kind of like that. It's like people are still running off, they're still accepting the assumptions of work that was done 100 years ago. And in many cases, those assumptions have been seriously challenged in the subsequent years. But unfortunately, because the way that a status quo hollow paradigm maintains itself is that it excludes question and doubting. And therefore it isolates the believers in a kind of a, like circle with their wagons circled, and they don't become aware that those assumptions have been successfully challenged.
With all the articles you have in here, I'm wondering, and your lifelong scholarship of the subject, anything surprise you as you were reviewing these articles, 50, 100 years old? Did we have any light bulb moments going on?
For me, the biggest light bulb moment was looking at the totality of all the essays once they've been assembled, and they're mostly, but not perfectly, in chronological order. And part of the purpose of that is to allow us to see how the knowledge is developing over time. And a number of the writers lots of them are reading one another's work and quoting them and, taking things a step further. So that was to me was I put it together and I was like, holy moly, this is like serious, this body of work. I mean, it includes Justice Stevens' article from the Pennsylvania Law Review, and I was especially pleased to be able to include that after the grossly intemperate and unprofessional attacks on Justice Stevens that came on him after his death by certain members of the professoriate. And
Don't ignore the press in that. I was just flabbergasted in trying to get the Washington Post to do a piece on him and on his writings, and the arguments I got in return were despicable. I mean, well, you know, they were ignorant, and you know, it couldn't. Yeah.
Right. Well, any hollow status quo depends upon uninformed opinion in order to maintain itself. And what I think is happening is that gradually, and I compare it now to a relay race, because once upon a time I thought that I was going to see this giant transformative wave, you know, like 10 years ago or 15 years ago or something crazy like that.
Yeah.
It's a relay race. And the good news is the runners who are behind us handed off a lot of really great stuff. And that's what I wanted to do in this book, was to bring that forward and say, look at what happens when you look at all of this together. Suddenly, the arguments about how bad Shakespeare's law is, they just don't hold any weight anymore. They cannot withstand the authoritative opinion, not only of the essays in here, but also Sokol and Sokol's Law Dictionary, which is frequently cited and quoted in this book, which comes to the same conclusion that, you know, Shakespeare had a very sophisticated knowledge of the law. So that was one thing. The second thing, in answer to your question, is that I struggled in writing the introduction and the conclusion to convey a new idea that's not in any of the other essays, which is that Shakespeare is also not looking at the law just from the point of view of a courtroom situation. He's also looking at the law from the point of view of a deep immersion in the whole history of Judeo-Christian and maybe non-Judeo-Christian to some extent, but mostly Judeo-Christian teachings about law. And so when Duke Vincentio, in Measure for Measure, at the climactic moment of the play, really, still in disguise, says to the distressed Isabella, who has been sexually abused, and he is going to plead her case, and he says he says the following: by every syllable a faithful verity, the Duke comes home tomorrow, nay, dry your eyes. That last being a little bit of stage business. Okay, the cue that Isabel's supposed to be weeping at that point. But that phrase, by every syllable, a faithful verity, is a fairly unambiguous rewriting of what Jesus says in Matthew 5:18, I believe it is. Think not that I come to destroy the law, I come to fulfill the law, a reference to Jewish law, right? And not a jot or a tittle will be put out until all things are fulfilled. The same idea of the smallest particle of language and the fulfillment of something in the future is present in both texts. Well, the interesting thing is, of course, that as Oxfordians, we know that by every syllable of faithful verity, language that otherwise, what the hell is that doing there, right? It just seems weird. Well, what it's doing there is sounding out a play on the De Vere family motto, nothing truer than the truth, vero nihil verius. And we can add to that, and this to me was the most, this is the thing I realized that just boggled my mind, because I've written about this play in my dissertation, and some of what I'm telling you I've known for a long time. But I finally focused this time on the importance that the character who says this, sometimes just called the Duke, his full name is Duke Vincentio. Duke Vincentio. And that EO ending should sound familiar to those of us who have read or watched a number of Shakespeare's plays. We have Mercutio, the mercurial guy,
Right.
in Romeo's friend. We have Romeo, the Romanio, the lover. We have Benvolio in the same play, which means well-wisher to EO. And we have Malvolio, which means ill-wisher to EO. Well, it turns out that in all of these Italianate EO ending names, the author is playing around with the initials of his name, Edward Oxenford, or EO, something that he began doing as a young poet long before these plays were ever written. And of course, Duke Vincentio, if Benvolio is the well-wisher and Romeo is the lover and Mercutio is the one that's ready to fight the duel, what you have in this case is Vincentio is from vinco, the Latin verb for conquering.
Winning, right.
So Duke Vincentio is the EO who conquers, not through force of arms, but through his cleverness and his good-heartedness and his self-awareness and his commitment to justice. He will.
Do we know of anybody that applies to?
Well,
I'd guess Oxford, but what do I know?
Well, yeah, right. I mean, and you can see all of this in his life. He was probably one of the most generous people that has lived. He was generous not only in his art, which is probably the most important part of his generosity, but he was a very generous patron, not only of the arts, but of philosophy, music. He believed in the importance of the arts in a culture and in a society to provide human content and relief and education. So you get a very different Shakespeare, right? As opposed to this happy-go-lucky guy who's just trying to put on some plays to make a buck and he's aimed at entertainment. The Shakespeare we're talking about really is thinking about the big questions of his day and ultimately the questions of our day, because they're really not any different.
Yeah, of all days. All right. So I got two more questions. One, I gave a talk a year ago to some college students at University of Virginia, at James Madison University.
Okay, great.
And college seniors and first-year grad students all going into teaching, they all knew about Oxford.
Oh, great.
I thought I would get, I don't believe it, who is this? But they all knew about Oxford. So their questions were a lot different than I was really expecting.
Yeah.
So that was a comment. How do you get your knowledge of Shakespeare and the law out there beyond the book, beyond this talk, hopefully? But how do we get you on the road to spread the word?
Well, I think that I've sent a few copies, advanced copies of the book to several law reviews, and we're actually making a correction based on some feedback we got to one of the credits in one of the articles, and that's, I believe, done. So now we've got a book that should be pleasing to our core constituencies. And I think that I don't know exactly who to send it to, but I think that's something that could have some thought put into. That I also sent it to I won't say his name because I don't have his permission, but I sent it to a real legal superstar who does a regular YouTube program that's followed by very many people. And I just felt he is an influencer, and he was someone who I just enormously respect for the work that he's doing right now in defending the rule of law in our country, which you and I both know vigorously needs to be done right now.
Yep.
So, you know, I think that he liked it. I don't have any proof of that, but I think it's good enough that we can begin reaching out to those kind of folks, and because there are plenty of people who are, I mean, lawyers have, here's the key point that I should say, lawyers and judges have always been interested in the authorship question. And one of the main reasons they've always been interested in it, and many lawyers have been Shakespeare scholars, by the way.
Yeah.
Okay. Yeah. And some of the more interesting, Robert White, I'm forgetting his middle name, but really important 18th century Shakespeare scholar, and by no means an anti or a post-Stratfordian. He was quite definitive as a lawyer that Shakespeare's knowledge of the law was sophisticated, even though he didn't really figure out, I think, how he could reconcile that belief with the traditional story, but he was honest in that assessment. So that goes back a long way. And one of the things that was added to the footnote was of the book is the acknowledgement of the University of Tennessee 2004 Symposium on Shakespeare and the Law, organized organized by Professor Jerry Phillips. And I believe that was where I first met Tom Renier, in fact. So there seems to be a potentially large constituency. I mean, this is large in relative terms, right? But there is also a law and literature movement within scholarship of people that believe that we should be talking about both of these things together and looking at the ways in which law and legal ideas and ethics more generally is a part of our creative fiction.
So what's next for you in terms of scholarly research and or another book?
Well, I'm still working on this De Vere poem series, and the second edition of the first volume is about to come out, and the second volume is about to come out. After those, and these are all projects that I've been working on for a really long time. So it's not like I've done all this writing in the last 2 years or something crazy like that. But those are coming out. And then after that, the two that we're working on now is a book on the first folio that we're hoping to have available by the spring of 2023. And that will include a really large, if not comprehensive, selection of articles that have been written on and cover all kinds of aspects of the first folio. We're going to try to contextualize it historically, something that mainstream Shakespeare scholars seem to be unable or unwilling to do. We're going to contextualize it historically as being published at the time of the Spanish marriage crisis. And we're going to talk about aspects of its design, aspects of the history of its reception, drawing on traditional scholarship and the often very good bibliographical work that has been done on the folio. Shakespeare scholars have been fine about doing detailed bibliographical data about how the book is assembled and stuff like that. It's the more dicey sort of political questions that they tend to avoid. So we're going to take in all of that. And this is an updating of a book that I originally did of edited essays in 2016. And again, the thing that really impresses me when I compare the two is how much in only 6 years our knowledge of the first folio has grown by leaps and bounds. And so what I put out in 2016 is interesting, but it doesn't really have a feeling of being complete or comprehensive. This is not going to be comprehensive, but it's going to be very complete compared to anything that anybody has ever done on
Great.
the first folio. Because I'm drawing on such a wide and diverse, group of scholars who are doing the work, and all I'm having to do is to go out and find it and figure out how to best assemble it so that each piece contributes to the effect of the whole book.
Thanks a lot for spending all this time with us. For those interested in Shakespeare, we know who was Oxford. This is the book you want to get. Shakespeare in the Law, How the Bard's Legal Knowledge Affects the Authorship Question. It is available on Amazon. The author is Roger Stritmatter. Run out and buy it, or run to your computer and buy it.
And it's a good deal, too.
It's a good deal.
How much is it? I can't remember. $12 or something crazy.
No,
like
it's 14.
14, yeah. I mean, it's a lot of book if I do say so myself for 14.
And you should. And it's a great buy. Thanks a lot. We will be in touch.
Okay. Thank you, Bob. Appreciate it.
Take care.
Bye-bye.
Bye-bye.